everyone, I'm Bita Delisi, and in this video we're going to talk about 4 things to be aware of that could possibly happen at your hearing. We get an overwhelming number of calls from landlords who get very excited when they have a notice of hearing because they think that once they go to the board and once their matter is heard, they're going to get the eviction order that they're hoping for. Well, that's not always the case. Here are 4 things that you need to be aware of. Number 1, your matter might not be heard. With a buildup of a backlog of about 80,000 applications during COVID, though the board is working efficiently to schedule hearings for these matters, there's still delays and there's still technical issues. The board has started holding hearings online and via telephone. However, when they schedule hearings for hearing blocks, they usually schedule about 100 or 110 matters. Oftentimes, the board runs out of time. If the board runs out of time and your matter is not able to be heard, then your matter will get adjourned to a future date. This can add 3 to 4 months additional on top of your current wait time. Number 2, you might not get the result that you're looking for. Please keep in mind that the mandate of the Landlord and Tenant Board is to preserve the tenancy. A landlord must show to the Landlord and Tenant Board that they've accommodated the tenant to the point of undue hardship. If you're not able to show the board that you've accommodated the tenant, then the board will put an order and they will make you accommodate the tenant. Number 3, you get the result that you're looking for. This is fantastic. However, what you have to keep in mind is that even though you get the order that you want, there is the possibility of a tenant delaying the process. And there is a possibility that you will also incur additional time and additional expenses to evict that tenant. Number 4, if your matter is heard at the Landlord and Tenant Board, you do have the right to mediate. Mediation is great because the parties can have an influence on the outcome of their matter. However, if you can't resolve the matter in mediation, your matter may be heard in front of the adjudicator. When your matter is brought forward in front of the adjudicator will hear one side and hear the other side, and they will apply the law. Keep in mind that in order to receive the decision of the adjudicator via an order, it could take 30 to 60 or up to 90 days depending on the board. Here at Stonegate Legal, we focus on resolving your matter prior to the hearing so that the matter can get resolved as soon as possible and you get the result that you're looking for. If you have any questions regarding a landlord and tenant matters, call us first.